afternoon and welcome to the City Club of Portland Friday Forum. I'm John Horvick, City Club President, and I'd like to welcome members and guests alike. Those of you who join us today at the Governor Hotel, and those of you listening on OPB Radio or watching on Portland Community Media. Today, Terry Fisher will discuss the impact and effectiveness of intellectual property rights for the fashion, music, and pharmaceutical industries. But first, some announcements. The generous support of City Club's corporate and media partners ensures we put on the state's best civic programs week after week. I'd like to thank our media partners, including Oregon Business Magazine. Our current Friday Forum sponsors are Bank of the Cascades, CenturyLink, Family Care Health Plans, Miller Nash, The Standard, and Stoll Reeves. We are grateful for your support and commitment to City Club's mission. Please join me in a warm round of applause for all of them. Join us next week when Congressman Earl Blumenauer will lay out his vision of why and how the government needs to change federal drug laws. You can learn more about club events, purchase tickets, and become a member on our website, pdxcityclub.org. As always, City Club will be live tweeting at today's event. You can follow or mention us at PDX City Club, and be sure to use the hashtag CityClub in your own tweets. We'll be having a Q&A session with Mr. Fisher at the end of today's program. Members, please come to the microphone to ask your question. And for all our audience participants, please locate the index cards on the center of the tables and write your questions on them during the forum. We'll collect them prior to the start of the Q&A. And now to our program. It's commonly said that providing innovators with intellectual property rights to their creations is necessary and sufficient to stimulate socially beneficial innovation. Yet comparing the fashion, music, and pharmaceutical industries can cast doubt on that generalization. U.S. fashion designers have few intellectual property rights, yet we see designers create a flourishing line of new fashions every season. In contrast, composers and recording artists enjoy extensive intellectual property rights, yet the traditional music industry is in crisis. And the generous intellectual property right and patent protections given to the pharmaceutical industry have failed to produce a socially optimal set of products. Terry Fisher completed his undergraduate degree at Amherst and received his law degree and PhD in the history of American civilization from Harvard University. He was a law clerk for U.S. Supreme Court Justice Thurgood Marshall. Since 1984, he has taught at Harvard Law School, where he is the WilmerHale Professor of Intellectual Property Law and the Director of the Berkman Center for the Internet and Society. We are now fortunate to have him with us in Oregon. Terry is the 2013-2014 Wayne Moore Center Chair of Law and Politics at the University of Oregon. And so without further ado, please join me in welcoming Terry Fisher to the stage.
Can you hear me okay through this? Great. Innovation, it's often said, accurately, is both precious and fragile. It's precious because it contributes so much to our economy and our culture. New products, new forms of art and entertainment create jobs, contribute to the growth of our economy as a whole, and provide America its most enduring source of exports, as so many of our other export products fade. Intellectual property rights in innovation are stable. Though, as I indicate, innovation is very important, it is also said to be fragile, meaning that in the absence of effective government action, we will have too little of it in fields on which we have come to depend. So why exactly is it fragile. Economists tell us that innovation falls into a special and especially important category of goods, commonly known as public goods. Public goods, as economists define the term, have two related characteristics. They are non-rivalrous and non-excludable. By non-rivalrous, it means that they can be used by an unlimited number of persons without being used up. And by non-excludable, it means it's very difficult, once you've made such a thing accessible to one person, to prevent others from gaining access to it for free. So to illustrate, contrast a poem and an apple. If I have an apple, my consumption of it is incompatible with its availability to you. Aware of that circumstance, I'm unlikely to surrender to you my apple for free. So an apple, in these senses, is both rivalrous and excludable. It's not a public good. By contrast, if I write a poem and I make it available to the first person, she can read it and enjoy it, and then make it available to 10 friends, who in turn make it available to 10 friends of theirs, with no diminution in the benefit to the first consumer. That circumstance, well known to the first reader, makes her typically eager to share it rather than reluctant to share it. So a poem, an example of innovation, is in that sense said to be both non-rivalrous and non-excludable. These characteristics help to explain why innovation is so socially beneficial, but they also create a hazard. The hazard is that, aware of these unusual characteristics, potential innovators will not innovate because they recognize their inability to charge beneficiaries thereof. The example, again, to return to the economics literature, most often deployed is a lighthouse. So suppose I own a piece of land on a rocky promontory. It's dangerous. Ships occasionally founder on it. I consider building a lighthouse. But brief reflection discourages me because I realize I will be unable, as a practical matter, to charge each of the ships who benefit from access to the lighthouse for the benefit they receive. Now, in theory, I could build a fence 10 miles out with a gate and charge the ships for permission to enter, but it's plainly impracticable. So, confronting this difficulty, I don't build the lighthouse. The parable actually has real-world significance. Almost nowhere in the world do private parties construct and operate navigation aids because they have no incentive to do so. They're built and operated by governments. Which leads to the more general point. Innovations of all sorts, like public goods in general, will be generated in socially optimal levels only if the government intervenes in some way to stimulate their creation. The way that most governments in the world, not all, for the last several hundred years have sought to stimulate innovation is through the creation and enforcement of intellectual property rights. Above all, patents and copyrights. It is part of our common lore now that, in the absence of a patent and a copyright system, the innovation on which we have come to depend would fall away. There's a great deal of truth to that proposition. In many contexts, it's correct, and fidelity to it is essential. But in some contexts, it's misleading. So in this talk, I will try to illustrate 3 settings in which it's misleading, and then draw some inferences or generalizations from these 3 examples. The first one is recorded music. In 1999, the recording industry was flourishing, both in the United States and globally. Total number of sales per year and total income to the owners of the copyrights in the sound recordings was at its historic peak. Not only were sales large and profitable, the cultural penetration and impact of sound recordings was extraordinary. Department of Commerce figures then indicated that, on average, American adults watched or listened to recorded entertainment 8 hours a day, 365 days a year. Now, immediately you think, well, wait, how did people work? It turns out those numbers derive from a combination of post-work entertainment and during work background. A more general point is that music, which composed the lion's share of those 8 hours, infuses our lives. Since 1999, the peak of the recording industry, it has taken a nosedive, an accelerating fall. So today, both in the United States and globally, the recording industry is half the size it was in 1999. Why? Well, there are many contributing causes, but most observers agree that the primary cause of the decline is the increasingly common, arguably promiscuous, redistribution of digital versions of sound recordings. This is true not just in the United States, but in other countries, and it's becoming increasingly brazen. An anecdote: some years ago, during the heyday of the Napster platform, which some of you may remember, I was giving a lecture to a group of lawyers in Brazil who were training to become judges. A lot, roughly 1,000 people in the room. And halfway through the presentation, on a lark, I asked if people would be willing to raise their hands to indicate if they had used the Napster software. More than half of these almost judges in Brazil had done so. Another example, a couple of years later, I was teaching my copyright class at Harvard, about 100 people in the room, and by chance the chief enforcement officer in the Justice Department for intellectual property rights was in town, and I asked if he'd be willing to come to the class and speak about criminal sanctions. And he very generously agreed to do so. So he made a little presentation to the class, at the beginning of which he said, well, just to start off, how many of you download music without permission? Now, this is the chief prosecutor in this field, and these are law students who have not yet been admitted to the bar. Half of them raised their hands. It was clear from his tone, and he confirmed thereafter that he was not gathering information to pursue them. He just wanted to break the ice a little bit and acknowledge the ubiquity of this behavior and its increasingly casual acceptance. So, although common, this practice has been devastating for the recording industry. So, what should we do if, this is an important if, but I'll assume it for these purposes, if we believe that an appropriate stimulus for creativity in music and justice for the work the musicians have done both demand that they be insulated against further harm and perhaps allowed to recoup some of the injury they've already sustained. What should we do? Well, the most natural answer is tighten the copyright regime so as to compel the people who are currently violating their rights to stop. We've tried that. Hasn't worked. Criminal prosecutions, very sizable civil judgments. In a few cases, prosecution of intermediaries have failed to stem the tide. Another possibility is we could encourage the creators of sound recordings to encrypt their works. In other words, to adopt technological self-help measures to curb non-permissive copying, and then reinforce their efforts with laws penalizing trafficking in encryption circumvention technology. We've tried that too. That's the Section 1201 of the Copyright Statute, the Digital Millennium Copyright Act. It too failed to stem the tide. So what might we do? Well, we might consider an alternative way in which the government could intervene in this space, could seek to stimulate innovation and reward innovators without relying on intellectual property. So again, return to the economics literature. Economists tell us that there are other possibilities, 3 of them. First, the government could, in the absence of adequate private innovation, conduct innovation itself. NASA would be an example. Agricultural research conducted in government labs, those are all examples of the government providing innovation that it doesn't expect private parties to do. Works in some context, very unlikely to work effectively in the context of music. Another possibility, the government could identify people that make convincing cases that they are in a good position to offer socially beneficial innovations. That principle, grants to private parties, undergirds a portion of the pharmaceutical industry, to which I'll return in about 15 minutes. Specifically, the NIH distributes approximately $27 billion a year to private parties, many of them universities, to conduct research that will ultimately issue in pharmaceutical products. Okay, again, it works in that context. And again, it's very unlikely that the government is going to be in the optimum position to identify the best musicians and give them grants. At least in the United States, in contrast to, say, France and Portugal, we have proceeded on that assumption. So what else? Well, there's one more possibility that we have on occasion explored in small settings. The government could create a prize system, could offer a reward to innovators, not ex ante, meaning before they have innovated, but ex post, meaning upon a demonstration that they have successfully provided something that the public at large values. The context in which that mechanism has been employed in the music industry already concerns radio broadcast of musical compositions, not sound recordings, it's a different thing, musical compositions. The way in which that system now works through a combination of government regulation and private parties is that a set of intermediaries, so-called collecting societies, keep track of what's broadcast over the airwaves, and they collect from all the radio stations a pot of money, roughly 2% of their gross revenues. They put the money into a pot, and they distribute it to people on the basis of the relative popularity of their works. Works fine. Several $100 million is distributed this fashion, and it doesn't involve government agencies identifying people who are worthy of receipt. Rather, the money is distributed on the basis of consumers' expressions of what they want, to which the radio stations, when selecting playlists, are responsive. So the principle of consumer sovereignty is preserved, but the distribution mechanism is not through the traditional channel of intellectual property. It's through a collective mechanism, the functional equivalent of a prize. So, the analogy is probably clear by now. We could, vis-a-vis internet distribution of sound recordings, employ a variant of the same approach. Declare the behavior to be lawful, but replace the existing copyright regime with a system under which the owners of the copyrights in the sound recordings that are in fact transmitted and consumed are paid in proportion to the relative popularity. How do we assess the relative popularity? Well, the technology for doing that in sampling materials on the internet is now very good. actually much better than we have by way of technologies for measuring radio broadcast. So where do we get the money from? Where's the pot assembled from? It's assembled from a levy upon internet service providers whose business models are currently based on demand for unauthorized recordings and who are currently not paying anything. So the system would not only be practicable, it would be fair. Okay, that's the first example of an arena in which intellectual property, the conventional answer to the need to stimulate innovation, may not be the optimal solution. Here's the second, drugs. So here we shift from copyright to patents. The pharmaceutical industry is not in as much of a crisis as the recording industry. Now, to be sure, there's some worrisome signs here. There's a slow in the pipeline of new drugs. There's corrosion of what has historically been the dominant market for pharmaceuticals. That's in the United States. More than 50% of the revenues of pharmaceutical firms come from the United States. But it's still pretty robust and very profitable. The health, relatively speaking, of the pharmaceutical industry is due in large part to the availability of product patents, not just in the United States, but in all countries that are members of the World Trade Organization. Product patents give the firms whose scientists innovate in this area roughly 10 years of exclusivity in distributing their products, which enables them to charge prices well above the marginal cost of producing the pills and make generous profits. And you say, wait a minute, 10 years? I thought patents were 20 years. They are from the date of application, but in the pharmaceutical industry, the process of refining the compound and then testing it through the 3 stages of federal regulatory approval consume, on average, a decade. So it's only a 10-year window of monopoly that the firms enjoy, but that's enough to earn them very generous incomes. Specifically, enough to offset the cost of the innovations in the first instance, which are astronomical. It costs on average now between $800 million and $1.2 billion to generate and test a new pharmaceutical product, taking into account the cost of the large number of failed experiments. So the industry is working pretty well. There are controversies around the edge. One in India just this past year. They're testing the ambit of patent rights, but it's working pretty well. The problem in the pharmaceutical industry is not that the industry is collapsing, rather that it is not producing a socially optimal set of drugs. The industry is generating, in the aggregate, too many of certain kinds of things and too few of others, measured by social welfare. Too many so-called Me Too drugs, drugs whose operating principle is essentially the same as an existing drug that offers modest therapeutic benefits, not zero, but slight. Example, there are now on the market 9 SSRIs for depression, whose function is more or less the same. Not identical, some of these drugs work better for some people than others, but the benefit of each new SSRI is quite modest. Statins is another context in which there are an excessive number of these from a social welfare standpoint. By contrast, we have too few drugs of other sorts. In particular, we have too few early-stage cancer drugs. We have lots of late-stage cancer drugs, drugs that will get you an extra month or 2 at the end of a horrific disease. And we have too few drugs that will prevent or offer a cure early in the progress of a cancer. Why? The reason is that to gather the evidence through stage 3 trials of the efficacy of an early stage cancer drug often takes longer than the 20-year patent window. So you don't get permission to employ it until you have forfeited monopoly control. So the system is biased toward cancer drugs whose efficacy is going to be apparent fast. And what are those? The ones that you take near the end of the progress of the disease. A lot of people die because of this distortion. Another example, we have too few vaccines. The wave of innovation in the mid-20th century in vaccines has largely subsided. This is especially problematic because vaccines, from a public health standpoint, are vastly better than medicines because they prevent you from getting the disease in the first instance rather than relieving of it after you have acquired it. Last but not least, from a social welfare standpoint, the pharmaceutical industry is generating too few vaccines and drugs that address contagious diseases in developing countries. HIV, tuberculosis, malaria are the big killers, but there are lots of tropical diseases, less famous, that we could curtail using the scientific knowledge we already have, and we don't. The human cost here is huge. 9 million people die each year in the developing world because they do not have access to either existing drugs at affordable prices or drugs that have not yet been made because the incentives for doing so are inadequate. Well, wait, why are the incentives to doing so inadequate if the potential market is so large? 25 million people in sub-Saharan Africa? It's because they're poor. 95% of the revenue of pharmaceutical firms in the United States, Europe, and Japan come from the United States, Europe, and Japan. 5% of their revenues come from the entire rest of the world. Not surprisingly, they concentrate on diseases or ailments common in the developed world, and they don't concentrate on diseases or ailments common elsewhere. So the fact that we don't have a socially optimal set of drugs to address contagious diseases is not a manifestation of evil on the part of pharmaceutical firms. It's a matter of economic incentives. Okay, so what do we do here? Well, here the answer is not, as it was in the recording industry, to displace the intellectual property regime, which is failing with something else. The intellectual property regime vis-a-vis pharmaceutical products is not failing. Rather, the answer is to supplement it with other kinds of stimuli that would shift the direction of research in more socially beneficial ways. So, for example, more government subsidies for underfunded kinds of research, prizes for the development of socially beneficial but relatively non-lucrative products. There's one more possibility, more radical and therefore less likely to occur, although conceptually intriguing. We could use the government to impose on pharmaceutical firms regulations analogous to those that apply to car manufacturers, who are obliged, in their entire fleet of cars, to adhere to an aggregate so-called CAFE standard, an aggregate fuel efficiency standard. They can figure out how to do it, but they have to adhere, and slowly over time the government has tightened the wheel, compelling increases in mileage. We haven't done that in the pharmaceutical industry, but we could. How? By requiring the firms to achieve each year an aggregate ratio, the numerator of which is their gross revenues, and the denominator of which is the number of lives they save. Measured using a metric employed by the World Health Organization called DALYs, that's disability-adjusted life years, which already gives us the information we need to assess the impact of drugs throughout the world. All right, as I say, that's conceptually interesting, but less likely to happen in the near future. Instead, we could and should employ targeted subsidies to supplement the patent regime to redirect research in more socially beneficial directions. All right, that's number two. Here's the third of the context: fashion. By fashion, I mean the shape of clothes, not the labels that are applied to clothes. Those are trademarks. I mean the shape. So is more easily seen in women's clothes, but men's suits change periodically. Innovation is very common in this area. And yet, in the United States, I'm going to exclude Europe for a moment, there's no intellectual property protection for those innovations. Fashion is constantly churning. It rolls over, roughly speaking, every 3 months. Why is innovation so fierce in this area in the absence of any legal protection for the innovations? Well, a clue, a possible explanation, lies in an unusual characteristic of fashion. In addition to being a public good, the sort I indicated at the outset, fashion is said to be a positional good. Positional good is a good whose value depends upon how many other people have it. So an easy example of these so-called network externalities is a fax machine or a telephone. That's a product whose value is dependent on how many other people have it, and it's simple, the correlation. The more people have fax machines, the more valuable is the one in your office. If no one else has a fax machine, it's worthless. If millions have them, it's quite valuable to you. Okay, fashion is the same characteristic, but it's more complicated. So when an innovation in fashion is first introduced, say the bandage dress or a shoe with a red sole, when it first is purchased by the very first purchaser, it has a high positional value because it's brand new and distinctive. As a few other people purchase examples or embodiments of the innovation, its positional value briefly goes up. Why does it go up? Because now the first purchaser is no longer at risk of being dismissed as eccentric. Now, she or he is on the cutting edge. But very quickly, as the market expands and more people purchase them, the positional value drops because it's less valuable to be owning and wearing a dress or a suit that's increasingly commonplace. And it continues to drop toward the asymptote of zero. Now, it actually never declines absolutely to zero. You can always wear the dress as a bathrobe, but it comes close to zero. So why is this relevant to innovation? The reason why this is relevant to innovation is because as the positional value of the good drops, it creates demand at the high end for the next wave. And the steeper the drop, the quicker emerges the new market for the next wave. So ironically, giving the innovators intellectual property rights and enabling them thereby to suppress competition and the spread of knockoffs would make the decline in the position of in the positional value of their products shallower and delay the emergence of demand for the next wave. High-end fashion designers benefit from the knockoffs of their goods. Now, there will come a point, if technology continues to improve, when the knockoffs come so fast that they can't exploit that first window. But we're not there yet. This helps to explain why, even in Europe, where, for reasons I won't go into here, there are intellectual property protections available for fashion innovations, it's rare for firms to use them. Why don't they register their designs? And when they register their designs, why don't they enforce them against competitors? Because they're sensitive enough to recognize it actually is not in their long-term interest. So, what should we do in this area? Nothing. Leave things alone, unless and until the technologies of copying get so good that the window in which the innovators can exploit their high positional value shrinks excessively. It may come to pass, but it hasn't yet. So, to summarize, intellectual property is often, but not always, the best way to address the fragile character of innovation. In some contexts, like fashion, just discussed, no form of governmental engagement may be necessary. The system is in optimal, stable equilibrium without any government support at all. In other fields, the example I've offered here is recorded music, some form of legal response is necessary, both to provide adequate incentives for innovation and to give musicians rewards to which they have moral claims. But it's not obvious that the best form of legal intervention is intellectual property, at least in the modern technological environment in which it's increasingly difficult to halt non-permissive copying of digital recordings. Some other mechanism, I've argued here for a levy system, would be superior. In still other contexts, like drugs, intellectual property may be working well to support innovation, but may not be generating the best pattern of products. To reorient innovators in more socially beneficial directions, we may need to supplement intellectual property with other forms of government support or control. Thank you very much.
Thank you very much. Now, if you have a written question on an index card, please hold it high so that City Club staff can collect it from you. And we'll now take questions from the floor. As always, we invite members to the microphone to ask their question. Asking questions at the Friday Forum microphone is a benefit of City Club membership, and membership is open to everyone. Before asking your question, identify yourself as a City Club member. Please ask only one question and ask your question as succinctly as possible.
Chris Andre, City Club member. Thank you so much. That was, that definitely expanded my horizons of my understanding of intellectual property and how to protect it. My concern is, hearing the word government, there are so many people now in our political environment who shy away from the word and any sort of government intervention into markets is seen as some kind of terrifying European evil. That's one of my concerns. My other concern is when a product is underwritten or supported based on its general popularity, my concern is for the edges. In permaculture, we know that the edges where everything's happening, transformation and exploration and innovation. So supporting the most popular thing may not necessarily be of the greatest benefit overall, over time. Thanks.
Those are both very good questions, but the import of them is, as I'm sure you recognize, intention. So if I take up the first one, I think you're right to observe that many Americans are uneasy with any proposal for increasing government engagement in this field. So the prospect of more deliberate government management of innovation chafes our justified suspicion of governments. But what that common attitude neglects is the fact that the intellectual property system itself represents a massive form of governmental intervention in the economy. Everywhere else in the economy, we adhere to the principle of competition. In fact, we have a large, powerful legal engine designed to preserve competition. That's antitrust law. So everywhere else in the economy, if I develop something new and it's successful, we expect and encourage others to enter into competition with me. The principle that underlies that practice is the belief that competition will drive costs down close to the marginal cost of producing the commodities, plus a reasonable or normal profit, and consumers will in the aggregate benefit, and the economy as a whole will drive forward. And so we are suspicious of monopolies, and we do what we can to corrode them. And when we can't corrode them, we regulate them. For example, municipal utilities. The patent and copyright systems represent a massive exception to that general stance. What patents and copyrights do is intentionally suppress, for limited periods of time, though in the case of copyright, not so limited periods of time, competition. Why? It's because the government has taken the position that deviation from the norm is necessary to support certain kinds of innovation. And there are many specific rules in the patent and copyright regimes that identify kinds of innovations we, the government, regard as sufficiently beneficial to support, and kinds we do not. So what I've been arguing for here is not more regulation, it's rather refinement of the directions of regulation. Intellectual property already is massive in this character. We need to adjust it in order to move in directions that are socially beneficial. For your second question, but do we always want to reward the most popular things? Well, maybe not. European organizations, in the film industry in particular, take the view that the public at large doesn't have a very good sense of what's worthwhile watching. And so they tax television stations and box office receipts. And they use the money to fund new filmmakers and innovative projects. It's hazardous, that undertaking. Deviating from the principle of consumer sovereignty is risky. So I'll close in saying, I actually, for reasons would take too long to explain here, would be happy to do so, but most Americans would not.
Mike Litt, City Club member. I want to talk a little bit about the Trans-Pacific Partnership. This is a massive commercial agreement being negotiated largely in secret for the last 5 years. The United States is leading this agreement, which involves 11 other Pacific Rim nations. WikiLeaks recently leaked a chapter on intellectual property. If you have read this chapter, you would be aware, I believe, that the United States, almost alone among these other countries, is pushing for extending certain drug patents by an additional 20 years. This would prevent or greatly delay the introduction of cheaper generic drugs and would cause harm to consumers both in the United States and especially in poor countries. I wonder if you are aware of that and if you would comment on it.
As you rightly point out, we don't know exactly what's in the current draft of the TPP because it has been negotiated like ACTA in secret. The grounds on which the Obama administration has sought to justify this seemingly anomalous practice is that it is executing instructions provided in an earlier statute by Congress, and therefore does not need to abide by the procedures that ordinarily are associated with the negotiation of treaties and their ratification by the Senate. That contention is yet to be tested. So how that comes out, I don't know. But you asked the question, I take it, well, what about the content to the extent we have been able, through these leaks, to discern it? In some respects, my view is that the United States Trade Representative, as best we can infer from the documents, is pushing too hard for the expansion of intellectual property rights, and the mandatory extension of certain patent rights, which you emphasize, would be an example. A much more sensible position is exemplified by the decision of the Supreme Court of India in the Novartis case, which curtailed the ability of pharmaceutical firms through evergreening, specifically by developing a new salt version of their drugs, to extend its effective patent life. That, in my view, is a better balance between, on the one hand, the very important incentives needed for pharmaceutical firms, and on the other hand, the importance of making access to these drugs, in that case, Gleevec, a cancer drug, available to the poor in India. However, not all parts of the TPP are misguided, in my view. And in particular, one provision the United States seemed, or seems, hard to tell, to be advocating is a change in the rules governing parallel importation of copyrighted goods to give American producers more power to prevent the reimportation to the United States of copyrighted products. Ironically, my view is actually that's socially beneficial. Why? Because it will result in lower prices for those products in developing countries. And the response of the American firms, if deprived of that power, as they more or less have been recently by the Kurtzsang decision, is that they will not change prices in the United States. They will simply raise them in other countries. So, in some parts of what appears to be in the TPP do seem misguided, but not all of them.
A question from the index cards here. How would you limit, quote unquote, patent trolls, excuse me, patent trolls who claim patent rights on generic concepts?
So, the term patent troll is the common term for an entity that is not currently engaged in the manufacture of any products or services, but holds patent rights and uses them to extract fees from people who do manufacture and distribute goods and services. Said to be a troll because they lurk under the bridge of commerce and reach up periodically to grab the ankles of legitimate passersby. A more neutral term, sometimes used in this setting, is NPE, or non-practicing entity. Doesn't have any of the resonance of patent troll, but avoids some of its negative connotations. This is a very difficult field because some trolls are plainly pernicious. They are parasites on the body of innovation. But there are others, using the definition I just provided, that are not pernicious at all. So for example, notice that most universities are, by that definition, patent trolls. Why? Because their scientists develop lots of technologies, some of which are patented, and they make them available to other people through licensing. But the universities don't actually manufacture the drugs or the widgets. They instead charge for permission to use them. And when somebody uses the tools without permission, they may, and have on occasion, brought patent infringement suits. So does that mean we should be shutting down in some way the universities who have, to take up the specific question offered here, patent rights in drugs? No, it would be terrible. Would cut off a very important source of innovation to suppress the university's efforts in this regard. Now, to be sure, there comes a time, after 20 years, when the drug falls into the public domain and generic versions begin to appear, but then nobody can assert the patent, or no one should be able to assert the patent, regardless of whether they're a troll or an operating company. Another reason why this is a very difficult area is that outside the context of universities, there are some intermediaries in this field. An example would be Intellectual Ventures, a large firm that arguably are performing a valuable social function in purchasing patents from small innovators who are not in a position to commercialize them, and then relicensing them to other firms that can. In other words, what intellectual ventures and other comparable firms are doing is making a market in intellectual property. Intellectual property has long been thought to be a very sticky environment, vastly more sticky than, say, the market for financial instruments or the market in land. Well, what these entities are doing is lubricating it, and generally speaking, our view is a well-lubricated market in any scarce asset is socially beneficial because it gets the assets into the hands of people who can use them most beneficially. So the bottom line is some trolls are bad and some are good. That makes very difficult the task of discerning which ones should be discouraged and how. The device that the patent system already provides, courtesy of the Supreme Court and the eBay case, is judges in patent cases are encouraged to deny injunctive relief to entities that are not practicing. In other words, a patent troll, relying instead on damages rather than injunctions. And damages to most defendants are much less threatening than injunctive relief. It's a form of compulsory license that allows commerce to go forward. Because this is in the hands of the judges, it means the judges can, if they're attentive to the nuances here, make case-by-case determinations of the legitimacy of the behavior of this particular plaintiff. So, in the end, my suggestion is don't condemn all trolls. Some are good or some are bad. And we already have a mechanism, courtesy of the eBay case, to allow judges, if they're thoughtful, to partially penalize the bad trolls while allowing the good ones to operate.
Ted Kay, City Club member. It appears that Google is trying to assemble all of human knowledge and has created some issues around compensating authors for their production. Would you please comment on that issue?
The way that Google is trying to assemble all human knowledge, as you put it, is to scan all of the books available in all languages throughout the world. And then to convert the scans into machine-readable form. So the ambition here is to create an extraordinary Library of Alexandria. Now, for the books that are sufficiently old, they're no longer in copyright. There's no problem here. Google does not face any legal constraint. So books, more or less, published before 1923 in the United States, they can scan willy-nilly and then make available to the world for free. That action, if they make good on their promise to make them available to the world for free, is an unalloyed social benefit. But there are other books, post-1923, that either definitely are or might be subject to copyright. And it's as to those books that Google has encountered difficulties. Okay, now, sort of a slightly awkward point here. Where does Google get all the books to scan? Well, they have arrangements with universities and the Library of Congress to use their collections to scan. One of the universities that was initially a participant in this process was Harvard, and I was a member of the group that was negotiating on behalf of Harvard University. Negotiating for what? Not to get paid, but to insist that Google make the materials, once they are scanned, available broadly and cheaply so as to make good on their public interest promise without revealing inappropriate details. Harvard withdrew from this negotiation. Now, in the end, that proved not to be particularly important to the overall project because there aren't many, relatively speaking, books that are unique in the Harvard collection. Google could get access to other copies elsewhere, so it wasn't fundamentally problematic. What really damaged Google was the failure of the settlement by which they sought to allay the concerns of the copyright owners. Judge Chin rejected the settlement, and forced Google to back up to a much more bare bones, less socially beneficial service. Okay, that's where we are right now. What should we do going forward? Well, one thing we might do is to secure a change in the law. This would probably require legislation to empower Google to do what they originally wanted to do and then provide all of us in the United States and in the rest of the world access to their collections. It's not likely to happen. So instead, we are working at the Berkman Center to help incubate a much larger enterprise, an enterprise that has now completely outgrown our ambit, called the Digital Public Library of America, which is sponsored, among other things, by the Library of Congress and the National Archives, that is proceeding less rapidly because we actually don't have $100 million, which is the cost of doing the scanning, to construct what we hope will be a substitute, but a substitute that is genuinely publicly available for free. That venture is underway. If you search for a DPLA, or Digital Public Library of America, you'll see the first stages of this project. There's a parallel one in Europe called Europeana. And so what we are trying to do, for better or worse, is create a publicly available copy of the world's knowledge.
We have time for one more question.
Dave Graff, City Club member, also a musician, composer, and a member of ASCAP, which is one of the two primary organizations, non-governmental organizations here in the US that monitors and collects royalties for musicians and composers. And in fact, what they do is they do surveys of major markets, and they figure out who's getting lots of play, and they go and they collect money from all the venues in the nation. Every little bar has to pay because they're sure that they're using licensed music there. And then they divvy it up to the people that had big numbers on their surveys. But as a composer, I can write a dozen songs, they'll get a little bit of play, I'll never see it. I've never seen a check in 30 years because my stuff's not being played on the Super Bowl or something like that. At what point do we come up, I mean, all these things you're talking about, we got a box of apples and a box of walnuts and a box of oranges here. Each one of these things you're discussing could take a whole program. At what point do we recognize that it is social norms, priorities, moral convictions? Like you say, these new lawyers that want to be judges, they're all downloading music for free. I've got music on the internet. I find people charging for the music I've got on my website for free. If I go Google my own music, it's being charged for by somebody in Asia or something. So at what point do we stop thinking about subsidies and grants and start thinking about actually the way that we look at things and what is fair and accountability? You need clothes, you need medicine, you don't need songs. Yet, people put their energy in. At what point do we come up with a new paradigm that people can collect for what they produce in that way?
You should tell me how many minutes we have. Okay. So I would quibble with some components of your characterization. For example, for better or worse, not every bar pays. There is an exception in the statute for small operations, both bars and restaurants. It's also ASCAP, BMI, and CSAC, which are the other organizations in this area, are somewhat more sophisticated than you describe. They're somewhat more attentive to the so-called long tail of small operators. But it's certainly true that some relatively unpopular folks fall below the minima necessary to collect any money at all. And that's unacceptable. So what's the solution? Well, the alternative that I offered here vis-a-vis digital distribution of music is contains within it potentially the correctives for each of the problems you identify. The source of the failure of ASCAP to compensate you is the imprecision of their counts and the cost of enhancing them. By contrast, it's easy to count the flow of materials flowing through the internet. In fact, it's already done. Webcasters have to keep track quite precisely of what they distribute and make that information available to other organizations that I haven't discussed here. So the technology exists, is in operation, and could easily be harnessed to create a system much more precise than the one you described in ASCAP, BMI, and CSAC. So my view is actually we don't need a fundamental change in attitudes. We need instead to avail ourselves of technological options we already have to treat people, creators, fairly. Now here's one more word in closing. A much more radical position, which is suggested by the very first comment, is it enough to create a regime that gives people what they are due on the basis of their relative popularity? Perhaps we should go further and offer compensation at smaller fractional rates to very popular people and larger fractional rates to unpopular people. In other words, to adjust the system to redistribute income downward and to offset the fact that, in the words of economists, distribution of income in the music industry now is so-called skew log normal in character. It means it's radically unequal. A very few people make a lot of money, and a whole lot of people make very little. Should we do that? Well, there are arguments in both distributive justice and fairness for doing so, but to start down that path is to incur all of the unease that the first questioner referred to, because that entails the government making a judgment that it knows better than the public at large which musicians are worthy of compensation. Thank you very much.
Indeed, we have run out of broadcast time for further questions, and we'll have to stop for the day. Please join us next week for a discussion of U.S. drug policy with Representative Earl Blumenauer. And as we close for today, please join me again in offering our sincere thanks to Terry Fisher. We are adjourned.